I do.
Please state your name for the record. Spell your last name loudly, please.
Paul David McManigal, McManigal.
Good morning, Mr. McManigal.
Good afternoon.
Oh, good afternoon. Excuse me. Where are you currently employed, sir?
I am currently employed as a sergeant with the Charleston County Sheriff's Office.
All right. And what are your duties there entail?
I'm currently assigned to the United States Secret Service as a task force officer on the cyber fraud task force.
All right. And generally, in your work on the cybercrimes task force, what does that entail?
I'm a digital forensic examiner, so I'm responsible for gathering electronic data from computers, tablets, cell phones, DVRs, vehicle infotainment systems.
All right. And when you say task force officer for the state, for the Secret Service is a federal agency, is that correct?
That is correct.
All right. But you're actually paid, and there's still an officer with the Charleston County Sheriff's Office, is that correct?
That's also correct.
All right. Okay. In this case, you provided some records in June of 2021 by an individual by the name of Dylan Hightower. Is that correct?
That is correct.
And what did he provide you?
He provided me with a electronic extraction from a cell phone that was extracted as binary data and not yet processed by forensic software.
All right. And when he provided that to you, did he tell you which phone it was from?
I believe he said it was belonged to Alex Murdaugh.
Okay. And that's the one he extracted from Alex Murdaugh on June 10th, 2021?
That is correct.
And what role, what did you do with that information that he provided you, with that data?
I was asked to redact potential client lawyer privileged information by reducing it down to a certain time frame that was more pertinent to the case and potentially reducing any privileged communication.
And did you make the decision of what to remove and what not to remove personally?
I did not. The decision of what to remove was made by Price Summer with the Ninth Circuit Solicitor's Office.
And she's an attorney?
She is an attorney.
All right. And you then produced a redacted copy of the digital evidence, is that correct?
That is correct.
And you provided that back to Dylan Hightower?
That is correct.
Did you provide any further analysis to the data itself?
I did not.
Did you redact any call logs from that data you're providing?
Call logs were not redacted at all.
All right. Let's move on. You've also been involved in one other aspect of this case. Actually, it's been marked as State's Exhibit 299. Do you recognize that, sir?
I do.
What is it?
This is a chain of custody form from the South Carolina Law Enforcement Division, which we commonly refer to as SLED.
All right. And do you see any handwriting on there that is yours?
I do.
All right. And what date did you sign that form?
June 9th, 2021.
Okay. And that form is related to what phone exactly?
There was a Apple iPhone 11 that was collected and brought to me by Special Agent Ryan Kelly with SLED.
Okay. And was that phone locked when he provided it to you?
It was.
All right. And did you, in your forensic investigation, did you attempt to unlock the phone?
I did.
Were you successful?
I was not.
And is that Paul's phone?
I believe it was. Yes, sir.
All right. And at this time, State would move to Exhibit 299 to evidence.
No touching it.
And I'm going to hand you what's been marked. Excuse me. I'm going to hand you what's been marked State's Exhibit 274. This is going to be for ID purposes only. And let me ask you if you recognize that, sir.
I do.
And what is that?
This is the iPhone 11 that was brought to me by Special Agent Ryan Kelly with SLED.
And that's the phone you attempted to unlock but were unsuccessful, correct?
That is correct.
And I believe on that bag, there's an orange sticker. You see that, sir?
Yes, sir, I do.
What is that orange sticker?
This is a sticker I place on devices that I have attempted to process or processed successfully.
Okay. And at this time, state's gonna put this in as ID only. This time, Andrew State's Exhibit 298. You recognize that, sir?
Yes, sir, I do.
What is that?
This is also a chain of custody report from the South Carolina Law Enforcement Division, SLED.
All right, and do you recognize your signature on that form, sir?
I do.
What date, excuse me, did you sign that?
This is August 12th, 2021.
And what does that form signify?
This is the date I returned the phone to Special Agent Kelly.
And at this time, state would move to place Exhibit 298 no.
Objection.
And so you attempted to unlock Paul's phone, correct?
That is correct.
And you were unsuccessful.
That is also correct.
Did you alter in any other way the data that was on Paul's phone during that time?
No, sir.
Okay. No further questions, please state.
Cross-examination. Good afternoon, sir. My name is Philip Barber. I'm one of the attorneys for Mr. Murdaugh.
Good afternoon.
I really just have one question. When you received this phone, was the battery completely dead?
The phone was powered off when I received it.
Did you charge the phone after you received it?
I did.
But do you know whether or not it was completely dead, battery dead? When you
I
received
do not recall if the battery was completely drained.
it? No further questions, Your Honor.
No further.
Nothing from the state. Please.
Thank you. You may step down.
Thank you, Your Honor.
Call your next witness.
Please go ahead. State calls John VanHoughten.
You informed the testimony about the report in this trial shall be the truth, so we got.
I do.
Take a seat and listen. State your name again for the record. Spell your last name.
Jonathan VanHoughten, VanHouten.
Mr. VanHoughten. Where are you employed, sir?
United States Secret Service.
All right. And how long are you employed there?
This April will be 3 years.
All right. And are you currently a law enforcement agent?
I am not.
Okay. And you're a civilian employee of Secret Service?
I am.
All right. But you do have a background in law enforcement, correct?
Yes, I retired after 21 years with the Columbia Police Department as an investigator. For the last 10 years, I was assigned as a digital forensic examiner with the U.S. Secret Service.
Okay. And you were a task force officer
Correct.
during that time?
Yes.
And you retired from the Columbia Police Department when?
April 20th, 2020.
And in this case, you were provided a phone by, I believe, Britt Dove. Is that correct?
Lieutenant Dove, correct.
Show you State's Exhibit 271. I want to see if you recognize this document, sir.
This is the SLED law enforcement, or South Carolina Law Enforcement Division chain of custody that was submitted to me by Lieutenant Dove.
All right. And do you recognize your signature on the form?
I did sign this one.
What day did you sign that form?
March 21st, 2022.
Okay. All right. At this time, State would move Exhibit 271 to evidence.
No objection, Your Honor.
Admitted.
Okay, I'm gonna hand you State's Exhibit 272. Let me see if you recognize that, sir.
This is an evidence photo that I acquired of the device that was submitted to me.
You took that picture?
I did.
And do we see a sticker on the back of that phone?
There is a yellow sticker on the phone.
What is it? Can you read that sticker, please?
It's it appears to be some type of case number, evidence number, identified as an Apple iPhone, the model number with a SIM, and an agency case number.
And if you just read the case number and the item number.
7021-0204, item number 10.
Thank you, sir. All right, so I believe you said March 29th of 2022 when Lieutenant Dunn provided you that phone number?
March 21st.
Excuse me, yes, 21st. All right, and why did he bring it to you?
It's my understanding that the phone was locked and SLED requested assistance of the Secret Service to unlock the device.
And at Secret Service, at that time, did you have tools available that could potentially unlock that phone?
Yes.
And did SLED have those tools, at least on that date?
At that time, they did not.
Okay. All right. And what tool did you use to attempt to unlock that phone?
For this, for my unlock attempt, I used a tool called Cellebrite Premium.
Okay. And Cellebrite Premium is a way to potentially break into, lock phones, correct?
That is the only use for that tool.
And just generally speaking, how does Cellebrite Premium attempt to unlock a locked phone?
It uses its proprietary software in an attempt to brute force the device.
Okay, what does brute force mean?
Brute force is if we don't have the code, we will attack the device, attack the data on the device to try to brute force the passcode to get the code for it to unlock the device.
And a device that's locked, why does it need to be unlocked for you to access the data? What underlying condition exists that prevents you from seeing the data?
Well, for Apple iPhone devices, there are two types of locks. There are before first unlock and after first unlock. Before first unlock is the phone is either powered down, it's been turned off and rebooted, or a code has been entered in too many times incorrectly. If you were to, an analogy for it, if you think of it as a bank vault, it is the before first unlock at which we have to brute force the device is like the big steel door.
Okay. And that underlying data is encrypted, correct? Otherwise.
Yes.
And you would not be able to read that data, correct?
I have to unlock the device to get to the data to decrypt it.
Okay. And so Cellebrite Premium, you said, attempted to do a brute force unlock, correct?
Yes,
And ultimately, was that attempt successful?
it was. It was successful because I generated a predefined dictionary to attempt first prior to the tool using its own dictionary.
Okay. And what do you mean by that? What does that mean?
Well, humans are creatures of habit. They like to use numbers that are relevant to them. Most people will use their date of birth, an anniversary, a child's birth, the death of a parent as the access code. So what we do generally is we get as many social engineered codes or dates that are relevant to the particular phone that we will attempt first. Once that attempt is no longer viable, the tool will use its own dictionary to start a hardcore brute force process.
And absent kind of getting lucky with a preceded number, if the Cellebrite Premium has to brute force its way through and unlock a phone, how long would that take?
So for a 4-digit phone, if you had a 4-digit numeric PIN code, we're limited to an attempt of 146, maybe 145 attempts per day. So a 4-digit code has a maximum possible numeric value of 10,000 attempts. So at 146 attempts a day, it would roughly take a little over 2 months to 68 days to unlock that phone. Adding 2 extra numbers to a 6-digit, going from a 4-digit to a 6-digit, there are approximately 1 million possibilities now. At 146 attempts per day, it could take upwards 19 years.
All right. Now, you said that you can only do 146 attempts a day. Is that correct?
Based on technology at the time and current technology is progressing, so it is getting faster.
Okay. Why is the software limited to just 146 attempts a day?
This is a security protocol chip built into Apple. It limits the time frame that somebody can attempt to brute force a device. The first it's an average of 1 attempt every 15 minutes.
All right. But ultimately, you said you seeded several numbers into Cellebrite Premium to give it some potential guesses first before just start going through all the other numbers, correct?
Yes. Once I start the brute force process, there is an option for me to enter my own dictionary or numbers that are relevant, that I think is relevant to the user of the device. In this case, I entered a number that successfully unlocked the phone rather quickly.
Okay. And what was that number associated with?
I believe the number was associated with the date of birth of Paul Murdaugh.
Okay. All right. And so once you successfully unlocked the phone, what did you do with this?
I notified Lieutenant Dove that the phone successfully unlocked. I advised him that I was going to be getting a full file system extraction since I still had the phone in my possession. Lieutenant Dove provided me with an external hard drive to place the extraction on, at which time I did.
All right. So you did a full file extraction and placed it on a hard drive, correct?
Correct.
Now, did you examine the contents of that full file extraction?
I did not. SLED has their own examiners. We did the extraction for them, but they analyzed the phone.
And so the data you placed on a hard drive and provided to Brick Dove, is that substantially the exact same data that you extracted from Paul's?
It is.
So is it changed in any significant manner?
It has not.
I'm going to hand you State's Exhibit 273. Do you recognize that document, sir?
This is the South Carolina Law Enforcement Division chain of custody where I returned the phone to Lieutenant Dove.
All right. And do you recognize your signature on it?
I do.
All right. And what date did you sign that?
March 24th, 2022.
All right. And you then provided Paul's phone back to Lieutenant Dove, correct?
Correct.
At this time, State would move to enter Exhibit 273 with evidence.
Submit it.
Okay, and I'm going to show you what's been marked as ID. I believe this is 274. Do you recognize that item, sir?
Yes, this is the phone I received.
Okay, and that sticker on the back,
It matches the photograph that I took.
the photograph we put in evidence, the sticker on this phone matches that, correct?
It does.
Okay. All right, one last question, Mr. VanHoughten. There have been a couple questions about Faraday bags in your trial. What is a Faraday bag, sir?
A Faraday bag is basically what it is a bag that shields electronic signals from entering or exiting the bag.
Okay. And what is the danger, by placing a phone in a Faraday bag, what is the danger you're trying to prevent?
We're attempting to prevent a remote wipe or remote destruction of the data on the device.
Once law enforcement takes a phone into evidence or custody, are there other ways to prevent a remote wipe?
Absolutely. Powering the phone down completely, not leaving it plugged to a charger, removing the SIM card, or the easiest is to place the phone in the airplane mode. It'll disable the cellular data and the Wi-Fi signal.
And you said that the danger is the phone could be remote wiped.
Yes, somebody with the account username and password could log into the iCloud account and set a remote signal. That signal will remain on the tower or on the network until the phone is reactivated. So yes, somebody would have to have the username and the password to log in and commit that offense.
Okay. And was the phone that you did an extraction of, was it wiped when you received it?
It was not.
Nothing further for the state for this.
Examination.
No questions, Your Honor.
Thank you. You may step down. Yes, sir.
Your Honor, before the jury brought in, I have a matter of law I'd like to deal with.
Yes, sir.
Your Honor, we've been informed by the Attorney General's been very accommodating. We tell him we were going to call on call this morning. One of the witnesses would be Brett Dove, and Brett Dove, I think they'll agree, is the person that did retrieve the extract from, you heard the Secret Service agent this morning, and did some analysis on it. I'd like to show the court. Is this working? Can I have the online? State's Exhibit number 299. Okay, and this is, wait, just let me have you push it up in just a minute. You don't need to. That's a receipt of property for Paul Murdaugh's phone. And if you'll slide the thing down a little bit, no, the other way. you'll see that Bobby, what's his last name, Bancroft? Received it from David Owens, who gave it to Bobby Bancroft, who then gave it to who? R. Kelly. Right. And then Paul McManigal, we heard from this morning, gave it to, he was at the Charleston Sheriff's Office, gave it to, whose name is that? Looks like Brian Heddick, who gave it to, well, it got to Brian Heddick at Computer Crimes, I guess by Ryan Kelly. The point I'm trying to make, Judge, let me show you the second page, is there are a number of people in the chain of custody on this phone who haven't testified yet. As a result, if Mr. Dove is allowed to testify about the contents of the phone, which he received from Secret Service, we believe that breaks, that would not complete the chain of custody. All we're saying is call these other people, and I mean, they're not going to be long witnesses, to complete the chain, to authenticate that what exactly came out of that phone was the phone that was found at the scene on Paul Murdaugh's body. I don't know if this is complicated or not, but it seems to me that they ought to have to do that.
Mr. Waters?
Thank you, Your Honor. Just very quickly, as we look at the chain on and I'll take those, thank you, on Paul's phone, and again, Mr. Conrad is going to call Lieutenant Dove here in a bit. We've had testimony from Jason Chapman about David Owen securing that phone. We've had introduction into evidence, Your Honor, without objection of both of these chain sheets. There was no qualification or objection to the information on these chain sheets, no hearsay objection or anything like that on both of these, which carried the chain all the way through. And then, of course, but we have testimony about the collection of that phone. We have testimony from multiple witnesses about the manner in which agents secure phones and the likely and the rest of that. And then we have testimony about that phone going essentially through a couple of couriers to Paul McManigal, who just testified as to his involvement with that phone, as well as to his delivery of that back to Lieutenant Dove. And then you've had testimony from Agent VanHoughten, who received that phone and analyzed it and then delivered that back to Lieutenant Dove. And Lieutenant Dove is going to be here to complete that chain. So if you look at the case law, and we do have some cases prepared if you need them. Where's the copies of those for you, John? This is not fungible evidence, and the case law is very clear, Your Honor, that chain, you don't have to call every single person that touched the evidence throughout the way, that it only needs to be established as much as is practicable, and I think we've done that in great detail. In any
That's a critical question. Is it fungible or non-fungible? Is a cell phone fungible or non-fungible?
If you look at the exterior, it's fungible. You can't tell one iPhone 11 from any other one until you open it, okay? But is the phone that was found at Paul, is that the same phone? And that's why you have the chain. It was cracked open and they got the material from, they want Doug to analyze. It is, this is an iPhone 11, Your Honor. It's not Paul's.
and Your Honor, again.
Fungible or non-fungible?
I say that it's not fungible, Your Honor. And again, I think we've had, it's clearly not fungible, and there's been
Clearly not fungible. You say clearly, what do you mean?
well,
Generally, when things are clear, then we don't have a debate.
fair enough. That's kind of point. I strenuously object, Your Honor. I apologize. But anyway, Your Honor, when you look at something like cell phone evidence and you look at the class of types of evidence that are clearly fungible, those two are I think, different in the manner in which they exist and the manner in which they are. And I'm not aware of any case that's ever held a cell phone as to be fungible. It is a physical item. Additionally, this particular one, I'm sorry, John, what does that say? Right. And additionally, this particular cell phone has a serial number and an IMEI that is specifically identifiable. The cell phones are not fungible. They are specific. They have specific identifying information like that. And so, again, I think that given the weight of that and the weight of what we have established, we more than established the chain.
No. Chain of custody, I'm sorry. These, I'm sorry, I apologize. Your Honor, I note on this chain of custody, There's no serial number. There's no IME number. There's nothing on this document. If you have it's State Exhibit 298 and 299. There's nothing on these indications. Matter of fact, the description is Paul's cell phone. There's no identifying data on this whatsoever. And then, by the way, I think we've been sort of lax. We should have asked all these witnesses how they know it was this cell phone. They never testified to serial numbers. That's water over the dam, under the bridge. But perhaps I should have asked that.
Well, and again, Your Honor, these came in without objection associated with testimony about that specific phone that people like McManigal and Agent VanHoughten have specifically identified as associated with these chain sheets and with that specific phone. So again, I think that's a specific identification, and they are not fungible in that regard.
Again,
Case that you said you have,
Your Honor, and I've got a copy right here. This isn't specifically, may I hand it up to Your Honor?
tell me about the case. State
again,
v.
Your
Pulley.
Honor.
State v. Pulley, yes, sir.
All right. And again, this is just a general, this isn't related to cell phones in specific, but it does talk about, establishing the chain of custody as far as practicable. And again, it talks about where the evidence establishes the identity of those who have handled the evidence and reasonably demonstrates the manner of handling of the evidence, which we've had testimony as to both of those. Our courts have been willing to fill in gaps in the chain of custody due to an absent witness. Proof of the chain of custody need not negate all possibility of tampering so long as the chain of possession is complete. It goes on, Your Honor, and that, I apologize, that was from Head Notes 5, 4, 5, and 6. It goes on to talk about a perfect chain of custody is not required. I think the evidence here on the whole has been more than sufficient to establish the chain. And additionally, even beyond that, I think that none of that precludes Lieutenant Dove to testifying about, given the foundation that's been laid, testifying about the contents of that extraction, pending, any additional witnesses that will come in. I don't think that's precluded at this time either. He can still go forward and testify as to the extent of his testimony about that extraction, and certainly understanding that any additional witnesses, are still forthcoming. So I don't think that precludes him from testifying as to the contents of that extraction.
Your Honor, with all due respect to the Attorney General, footnote says, when establishing Head Note 4, when establishing chain of custody of fungible, bolded evidence where multiple people have handled or analyzed the substance, the identity of the individuals who acquired the evidence and what was done with the evidence between the taking and the analysis must not be left to conjecture. And there's nothing in any document we've heard or any witness that is specifically identified that I got cell phone M4381 and gave it to somebody else and said, I got that same cell phone because it had the same serial number. If that's not conjecture, I don't know what is. And again, what's the big hurdle here? You've got 3 people he needs to call. Unless there's a problem with one of them, that has signed this document that didn't have it. And I think that this is an important piece of evidence. And we ought to just require what's required by this case and every other case where there's a fungible item.
Your Honor, again, going back to Head Notes 4 and 5, testimony from each custodian of fungible evidence, however, is not a prerequisite to establishing a chain of custody. Again, we've had testimony about collection, we've had testimony about the manner of collection, and we've had testimony from those who actually analyzed it in the interim to get to Lieutenant Dove, who will then complete that analysis. So we've got testimony about collection, we've got chain sheets supporting that, and then we'll have every person who actually analyzed it. And I think that's more than sufficient chain to establish its admissibility at this time.
Anything further? Last word.
Nothing from the state, Your Honor.
Nothing from the defense.
To the extent that this is a motion to exclude this testimony, the motion is denied. I do not believe that the portion of this case that State v. Pulley that says the identity of individuals who acquired the evidence and what was done with the evidence between the taking and the analysis must not be left to conjecture. I believe that a cell phone is not a fungible item, but it is complicated to the degree that there was analysis done with the cell phone, but the testimony, particularly the testimony of VanHoughten, sufficiently establishes that this phone was not tampered with, could not be tampered with, and I believe that the state has sufficiently established a chain. Cases have held that a perfect chain is not necessary, and I believe the state has sufficiently established the chain of custody to the degree necessary that the next witness can testify. So I deny the motion, and the objection is noted for the record.
Your Honor, make sure the record. Wait, all due respect, we accept her from the rule.
I said it's noted for the record, yes.
From the old school, I'm sorry.
Ring the jury.
Witness will testify